Ready, start. Although the appellant was not named in the FIR, his name transpired in a disclosure statement made by the co-accused Deepak Dogra. Latter co-accused Hassan is reported to have also stated before the police that he had kept the stolen judicial file in his saloon on telephonic instructions received from the appellant, who happened to be a customer of Hassan. Admittedly, upon investigation made by the relevant Deputy Commissioner of Police, a closure report dated 19th May 2022 under Section 173 within bracket 2 of the Code of Criminal Procedure 1973 was filed before the learned Additional Chief Judicial Magistrate, Ludhiana. However, by an order dated 4/7/2022, the magistrate refused to accept the closure report and in fact discarded the same with direction to the investigating officer of the case to continue with investigation and to 1 IPC report developments by 11th July 2022. From the counter affidavit filed by the respondent state of Punjab, it appears that although challan has been filed against the co-accused Chetan Kumar and Deepak Dogra, investigation against the appellant is still in progress and that it is proposed to file challan/final report upon completion of investigation. It has not been disputed before us that the appellant was called thrice by the investigating officer and that he had joined the investigation. It is also undisputed that a computer monitor, which allegedly was stolen along with the judicial file, has since been recovered. In view of the aforementioned facts and circumstances, that investigation against the appellant has remained incomplete for more than 2.5 years, even after further investigation was ordered, coupled with the fact that the appellant has joined investigation, we are of the considered opinion that his custodial interrogation is not warranted and that the interim order passed by this court giving protection to the appellant from arrest ought to be made absolute. Ordered accordingly. Accordingly, we set aside the impugned judgment and order. It is directed that in the event of the appellant being arrested, he shall be released on bail by the trial court on terms and conditions to be fixed by the trial court. It is made clear that in the event in future the appellant is found to be prima facie involved in a similar offence as it has transpired or acts in any manner interfering with the administration of justice and a complaint to that effect is received by the Bar Council of Punjab and Haryana, the council may take appropriate steps according to law, including suspending the license of the appellant for such period as it may determine. Needless to observe, the appellant shall not directly or indirectly, by making inducement, threat, or promise, dissuade any person acquainted with the facts of the case from disclosing such facts to any police officer or to the court. We also clarify that the observations made in this order and grant of bail to the appellant in application of arrest will not be treated as findings on the merits of the case.